You'll remember the Director of Public Prosecution, Paul Rofe, was sprung for getting a skinful and hopping in his car, and for his passion of punting on the job.
I have a contract till 2006.
His boss, the Attorney General, has given him another reprieve, but the real issue is, and always was, the way he's done the job. Well, you be the judge.
Yeah, I think I've been upfront about everything with Keogh.
We beg to differ. Like the Keogh case, there are others which raise suspicions without getting to the DPP's desk.
There are still very many questions unanswered, and it's when the questions aren't answered that you have to have some grave concerns.
MP Francis Bedford has been carrying the torch for the Wilson family, left angry and suspicious by the inadequate police investigation of their son Peter's death.
The Wilson son's body was found on the road in circumstances that were never actually clearly explained. The time of death, where he died, even whose clothes he was actually in the day he was found.
It's a case which deserves exposure. Sadly, there's no shortage of those. And now the Attorney General has joined in to smooth over the mounting scandal arising from the death of Anna Jane Chaney and the conviction of Henry Keogh. First, here's a sample of Rofe's rough justice in that matter.
A fit, healthy 29-year-old girl doesn't drown in the bath.
Correct? No.
I would get approximately 10 to 12 cases per year referred to me to examine the heart in precisely that scenario where a young person has died suddenly and nothing has been found at autopsy.
Professor Tony Thomas is a highly respected Adelaide pathologist who's an expert on the subject of sudden death in young people.
As I've said, young people unfortunately do die suddenly and unexpectedly. And sometimes, even after very exhaustive examination, you still cannot find the cause.
Then there's the failure to follow basic procedures at the scene of Anna Jane's death.
I can't think of any evidence that might have been left that was destroyed.
Correct? Wrong. Almost nothing was properly checked that night. Even the bath water was emptied without testing.
I think it would be part of a sound forensic principle that one would expect to and want to examine all the circumstances surrounding the case.
And what about makeup being applied to the body?
I don't know what you're talking about.
Acceptable? Well, no, it's not. Next, the autopsy. Procedures demand the police crime scene investigator be present.
My understanding was there were people present at the post-mortem.
Right? Could he be wrong again?
I'd have to check that.
We have no statements from any police officers saying that they were present at the autopsy.
One of the greatest travesties is pathologist Dr. Manock's use of black and white photographs to show bruising when colour is crucial, and when the procedures specify colour photographs. But were all the photographs actually provided to the defence?
Yes.
They could look through all of the photographs taken by police, taken by the Forensic Science Unit, and have open access to those.
Yes.
Right? Wrong yet again.
If it's true, then the photographs are inadequate because they fail to establish what actually happened. If it's not true, then it indicates that the prosecution misled the defence.
Furthermore, despite serious questions over his competence, Dr. Manock was allowed to conduct Anna Jane's autopsy unchecked.
That was the established procedure at the time, in my experience.
Is that right? No. Wrong. Another pathologist should be present. And what about what the DPP has to say about a reenactment to test the validity of Manock's theory on Anna's so-called drowning?
We never had a plan to reenact anything, as I recall.
Right? Wrong. This police running sheet notes the idea was discussed, but Rofe rejected it. Perhaps it would have raised more questions than it would have answered, based on Manock's questionable theory that so-called bruises on Anna Jane's ankle were the result of Henry's hand grip during the act of drowning.
I was quite satisfied with his competence. I don't think his evidence convicted Henry Keogh.
Wrong. How could Rofe possibly say this when the case rested from the outset on Manock's shoddy science? This is what he told the jury.
The grip mark on the left leg suggests Keogh murdered his fiancée by deliberately drowning her in the bath.
Now the DPP has convinced his boss, the Attorney General, to deny the existence of new evidence and to overlook the expert opinion of Professor Thomas.
The interpretation of some of the suggested bruising that was seen at the time of autopsy. In my opinion, there is very little evidence of that in the sections that were examined down the microscope.
Almost no proof of bruising.
Look at it, deal with it, clear the air, because it won't go away.
As far as I'm concerned, it has.
Wrong. You see, the most startling evidence is yet to be revealed, even though it's been available to the DPP. However, even putting the host of forensic failures to one side, what are the facts behind those insurance policies?
The information about the insurance policies was taken out of context and fundamentally misconstrued.
As Bob Moles, a former Associate Professor of Law at Adelaide Uni, says, the insurance policies were the prosecution's trump card. Their theory? Henry Keogh secretly took out 5 joint life policies, forged his fiancee's signature and then murdered her for the cash.
Such a crass thing to attempt that he would have no prospect of concealing the claims under 5 policies when he told all the companies that he only had one insurance.
One of the prosecution's key points was that Keogh kept Anna Jane completely in the dark about the existence of the policies.
He lied about what he'd told Anna Jane about them in the course of his evidence, and that was clearly demonstrated.
Correct? Well, wrong. And the proof? Before her death, Anna Jane applied to Bank SA for a number of small bank loans, the last 2 being in November 93 and again in March 94. In the box marked life insurance, she entered the figure $36, precisely the amount of her half share of the instalments on those 5 policies.
Look, if anybody looks at the evidence objectively, you'd have to assume that she did know about the policies.
To explain away this troublesome fact, Paul Rofe told the jury that this $36 was really a split between Anna Jane's mutual health and her disability insurance policies, despite evidence that one had lapsed and Anna had cancelled the other.
But it's absolutely clear that Anna Sheeny knew that the policies had been cancelled and that she didn't have any medical insurance. Absolutely clear that Anna Sheeny knew that the policies had been cancelled and that she didn't have any medical insurance. And Rofe knew that.
And then there's the DPP's claim that Keogh withheld evidence of the policy's existence.
Oh, they were very important, both what he said about them, and certainly he didn't come clean about them at the beginning, and it only emerged in dribs and drabs.
Right? Well, not really. Just 4 days after the distress of finding his fiancée dead, Keogh handed her super and 3 of the policies to the police. Just 1 week later, having located the remaining 2, he passed them to his solicitors, who gave them to police. In less than 3 weeks, the police had been given everything.
The defence argued at the time that he was upset about the death, that some of the people he was talking to didn't want to give specific information to. What did you make of that?
Oh, I mean, that was their explanation. It was there to be accepted or rejected by the jury. Again, clearly rejected.
Well, OK, but remember the jury had not been told of the serious questions over the competence of pathologist Dr Manick. They had not been given all of the evidence, which cast extreme doubt on any murder ever taking place.
And if the forensic evidence was flawed or fundamentally mistaken, then the jury might have considered the other evidence differently.
But if delays in coughing up evidence trouble the DPP, consider the case of lawyer Scott Aitken, 2 of whose children were killed when he crashed off the freeway with a can of petrol and dropping a cigarette when he says he was attempting to avoid hitting a dog.
With a witness from Mr Aiken's own law firm,
Yes.
who'd seen a large dog in the area,
Yeah.
but it sat on this information for 12 months. And
That's so.
And it popped up in the last week of the coronial inquest.
Correct.
In the light of all that, people were very sceptical about the...
I can understand the scepticism, but it was just another factor that was factored in, to my opinion, and that of the trial prosecutors.
The year-long delay, the coroner was told, was on legal advice. But standards seemed to differ remarkably. In the Aitken case, despite having Aitken's daughter, a passenger, being prepared to testify against her father, the DPP agreed to accept almost every argument put by the defence without a trial.
I mean, the rumour was that deal was struck over a few beers.
There wasn't a deal, it was the advice of the trial prosecutor that we couldn't prove the murder charge.
Aitken's murder charges were reduced to death by dangerous driving, and the judge had no option but to suspend his sentence. Aitken continues to work as a lawyer, now for a major law firm in Sydney.
I guess you've just got to ask, the public trust, whoever's in the job.
Trust. Now that's a fragile commodity, particularly when the Attorney-General Michael Atkinson, briefed by the DPP and the Solicitor-General, puts a report to Parliament lacking credibility in key areas, even playing down Dr Manock's failings in the infant death case.
Well, a number of allegations, and after the break we'll see what the Attorney-General has to say. Well, despite the evidence to hand, the Attorney-General has been adamant that there is nothing to investigate. But as Graham Archer continues his report, others believe that there is indeed plenty to question on a case that just won't go away.
That certain people were not prosecuted in relation to death is not attributable to the impugned findings of Dr Manock.
Right? Absolutely wrong. In fact, one person confessed to murder, but Dr Manock's diagnosis of death by natural causes put a stop to everything.
That put the police in a very invidious situation whereby they then were prevented from following up any other circumstances surrounding the case, and in effect the trail went cold.
Tony Thomas should know. He produced the final report for the coroner on the battered babies case, but our Attorney-General comes up with this.
The coroner did not find Dr Manock incompetent to conduct adult autopsies.
Correct? Totally wrong. While the subjects were babies, Manock failed to diagnose injury and infection common in both infants and adults. No specialised skills were required for that.
Not in that particular context of the interpretation of bronchopneumonia, or even, as I've said, fractured bones, which one would expect a forensic pathologist to deal with in adults as well as in children.
It seems Paul Rofe and the Attorney-General are desperate to stop the first worm getting out of the can.
There was no miscarriage of justice in the Keogh case. The verdict did not depend on Manock's pathology report, but on circumstantial evidence.
Correct? Wrong. Obviously, if the forensic evidence doesn't support murder, then the circumstantial evidence is irrelevant. But the most questionable statement is this.
There is not a trace of fresh evidence.
Wrong.
Well, I'm not sure how new evidence is defined, but there would seem to be a number of anomalies in the case that have never been tested in a court.
There is a mountain of evidence which could be considered new, but has never been tested, never been before any court, and Michael Atkinson should know that. But there are also serious questions over the handling of the evidence that was put to court.
The information that's gone to the court, do you think that's been dealt with satisfactorily?
I think one would have to say no.
In the meantime, Michael Atkinson seems to have been given the media Mike Rann front page treatment on criminal justice, sprouting the Get Tough on Crims chorus. Whatever the facts, increase the penalties. Perhaps getting the right people behind bars might be a better starting point. And the DPP, after 8 years, has discovered perhaps baby batterers should be put in jail too. Rather than reassure us, the official approach into the Keogh case and a host of others simply confirms the need for an independent inquiry into our criminal justice system.
The number of people in Adelaide who have concerns are still voicing those concerns. They should be investigated.
Because it won't go away.
Graham Archer with that special report.